In 2018, a 5-judge bench of the Supreme Court of India ruled that the right to life under Article 21 also includes the right to die with dignity. The Supreme Court further ruled that living wills and advance medical directives are valid, subject to certain strict guidelines, and also laid down guidelines in the course of the judgment. In January this year, the Supreme Court simplified the 2018 guidelines, making it easier for people to opt for passive euthanasia. In light of this, we discuss euthanasia and its legality in India.
Thanks, Sandhya, for the good introduction. I think it's a topic which all of us are very eager to know more and more about. So we will just get into the basics of euthanasia. So euthanasia is also known as mercy killing, and euthanasia is the practice of intentionally ending a patient's life to eliminate the patient from suffering and pain which is incurable.
Right.
Under the euthanasia, there are two kinds of euthanasia. One is an active euthanasia, where the ending a patient's life by using substances such as lethal injections or injecting with lethal dose of drugs, which is called as the active euthanasia. Now, the other kind is called as the passive euthanasia, ending a patient's life by withholding the treatment or any life-saving procedures which keeps the patient alive. Here, especially the Indian courts recognize only the passive euthanasia.
Right. We now look at what an advance medical directive is. Now, an advance medical directive is a written document by a person describing the medical treatment that he or she would want in the event he is not able to make an informed decision. Say that person goes into a coma or is in a vegetative state and is unable to make an informed decision, then the person writes down an advance directive stating his wish and will for the kind of medical treatment he wants to receive or not receive. We now look at a living will. Now, a living will is nothing but a form of advance medical directive. Again, a living will is a written document written by a person while he's alive. In addition to, the property and everything that is going to be divided, a living will is different to the extent that it details a person's wish on how he or she should be medically treated in the event he is not able to make a decision for himself. It's basically detailing his end-of-life treatment.
Absolutely. The most important thing is now we will deal with the legality of euthanasia in India. Now, historically, euthanasia was not recognized in India as anything which is legal, but that got changed with the Aruna Shanbag case. So let us look into the brief facts of this case. So Aruna Ramachandra Shanbag was an employed nurse in a Mumbai hospital in 1973. And she was sexually assaulted by a sweeper and strangled using a dog chain. The strangulation actually cut off the oxygen supply to her brain, and it resulted in a severe nerve damage into her brain and all her vital parameters, ending her up in a persistent vegetative state as such. So in 2010, a plea for death by euthanasia was filed on behalf of Aruna by a journalist and social activist. But in 2011, the Supreme Court, while considering the case, it did not recognize the living will, but however, it permitted the passive euthanasia in exceptional cases like Aruna's. Now, the Supreme Court held that the next friend of hers could decide on it. However, the nursing staff of the hospital, who were recognized as the next friend, opposed this entire idea of euthanasia for Aruna, and hence she continued to live. In 2015, Aruna died due to pneumonia after spending a whole lot of 42 years in a vegetative state and being cared for by the nursing staff of the hospital. In 2018, for the first time in India, in Indian legal history as such, passive euthanasia was recognized and further guidelines were issued for passive euthanasia.
We now look at the guidelines laid down in 2018 by the Supreme Court of India. An advance directive must be executed by an adult when he or she is of sound health and mind. The adult who is giving the advance directive must do so out of his or her free will, meaning there should be no pressure or coercion to do so. It must be in writing clearly, indicating when the treatment to further the life should be withdrawn. The advance directive must indicate that the executor, in this case, the executor is the person or the patient who is writing the advance directive. So the advance directive must indicate that the executor can revoke the authority at any time. It must also contain details of one guardian or close relative who's authorized to take that decision on behalf of the executor when he or she becomes incapable of doing so. The document should be signed by the executor in the presence of two witnesses and countersigned by the Judicial First Class Magistrate, or the JFCM in short. The JFCM will forward a copy to the district court where it shall be maintained both digitally as well as in a physical copy form. He shall hand over a copy to the municipality and the treating physician of the hospital.
Adding to the guidelines which you have said, Sandhya, there are a few more which I would like to share. So when the executor becomes terminally ill and is not able to take a call on any continuance of their life, then a physician who is treating the patient shall ascertain the genuineness of the same and inform the close relative or the guardian of the executor here. Now, a medical board also shall be constituted at least with 3 experts from the fields of general medicine, neurology, nephrology, oncology, psychiatry, who hold at least 20 years of experience to ascertain the status of the patient.
Right.
And they have to also certify on whether this advance directive can be acted upon. And this is said to be considered as the preliminary opinion.
Right.
Now, once the preliminary opinion is given effect to the advance directive, then the physician has to inform the JFCM. And he shall also constitute another board under the Chief District Medical Officer. Now, this board shall be constituted in the same manner as such as the preliminary board, and the doctors on this board also must visit the hospital and also interact with the patient. If they concur that this advance directive must be carried out, then the Chief Medical Office must also intimate the JFCM. The JFCM also visits the patients, and after the interaction is given, his final decision to implement the advance directive is given a go-ahead.
Right.
It is also to be noted here that there was no fixed timeline within which these medical boards must arrive at a decision. If the medical boards are not in any favor of giving effect to this advance directive, then the patient, which is here the executor himself, or his relatives or guardians, or even the physician who has the legal right to approach the High Court under the Article 226 of the Constitution, this could be a fairly time-consuming aspect, but they can approach the High Court for it to execute this advance directive as well.
Right. I'd like to initiate our viewers into the latest development on this in January this year. While considering an application from the Indian Council for Critical Care, the Supreme Court actually revised the guidelines relating to giving effect to advance directives. Now, one may wonder, why did the Supreme Court give the guidelines in the first place and revise it? See, the guidelines were put in place basically to ensure that the advance directives are not, there's no exploitation or unnecessary, taking of life. But it was found in the course of executing the guidelines that some of them are actually causing delay. For instance, when an advance directive is executed, it has to be attested by 2 witnesses. Additionally, it has to also be attested by the Judicial First Class Magistrate or JFCM. Now, that is substantially time consuming. Okay.
Right.
Also, there is the guidelines of 2018 did not lay down any timelines for when the medical boards, the preliminary board and the secondary board, have to submit their findings. Now, this is only leading to further substantial delay and thereby further, agony of life for people in coma and in a vegetative state. Therefore, in January 2023, that is January this year, the Supreme Court revised the guidelines. Now, for the benefit of the viewers, we'll just put it up as a card. For instance, if you could take cue from the card, in 2018 guidelines, the JFCM had to attest after 2 witnesses. Now, the 2023 guidelines have revised it, wherein his involvement is not necessary. A notary or gazetted officer can attest. Okay. Similarly, the constitution of the medical boards, the primary and the preliminary and the secondary boards were also put in place. In 2018, the guidelines said they needed to have a collective experience of 20 years, along with a team comprising of general medicine specialist, a nephrologist and an oncologist and a psychiatrist. Okay. And the hospital had to constitute that secondary board as well. Now, cut to 2023, the guidelines say that the experts who are on the medical board can have at least 5 years of experience. Okay. And the most important point there was the treating physician had to be part of the medical board, which was unlike the original guidelines. Okay. Also, the secondary board had to be constituted by the district collector.
Right.
The 2018 guidelines, now it is by the hospital itself. And the most important guideline is the timeline. The 2018 guideline did not fix any timeline relating to when the findings have to be submitted. But the revised guidelines say that both the preliminary medical board as well as the secondary medical board have to kind of arrive at their findings and submit it within 48 hours of their constitution interaction with the patient and the support staff.
So the revised guidelines of 2023 actually have ensured that the entire process is been kept within a timeline and there is no delay in any part. I think that's a very welcoming aspect which the courts have taken in the regarding with euthanasia as such. Now, also it is important that we all have the right to die with dignity. So the Supreme Court expressed that the government, in consultation with the medical fraternities, must arrive at a law which is relating to the passive euthanasia as such. Till such time the law is put in place, these revised guidelines will have to be followed to ensure that terminally ill patients or patients who are in a permanent vegetative state are given the right to die with dignity.
Right.
The right to die with dignity is very, very important as much as the right to live. So I think these guidelines will, as clearly mentioned before, will help the medical fraternity and also the patients to come to a conclusion and to ensure that they don't suffer for a long time, until and unless there is a law which is being passed in our country. So we hope that the viewers have found this episode of Euthanasia informative. Thank you so much for watching us, and we will see you next time. Until then, bye.
Bye.